FSU's blistering lawsuit against the ACC. Some have said, and I quote, "It's the kind of lawsuit that could shake college sports and potentially set off another unsettling wave of conference realignment if FSU succeeds in court and withdraws from the ACC." If you're watching on Warchant TV right now, you'll see a gentleman. His name is Michael Mestre, financial services litigator in the Charlotte area. He's a Noles, ladies and gentlemen, and he joins us on the Jeff Cameron Show now. A lot of big credentials. He's with one of the big boys, but we won't get into the weeds with all of that. I want to get your initial impression of the complaint, and did anything stand out to you when you first read it?
Yeah, Jeff, thanks, and thanks for having me on the show. My initial thought was that, like a lot of attorneys that I've talked to, this suit has some teeth, more than kind of what was anticipated, throughout this time. They bring forth a declaratory judgment action, which is basically, asking the court to, answer for the parties what is the enforceability of this contract and the grant of rights, as well as the multimedia agreement with ESPN. And so it's interesting to see, how the attorneys for FSU kind of went at it, and it will be interesting to see how this plays out in the future.
We've been told repeatedly that, quote unquote, the grant of rights deal is ironclad. So this is a two-part question to you. A, how did they come at it in your mind? Because you've been involved in big cases like this. And the other thing I would say is, if the grant of rights was ironclad, did it not seem excessive and even punitive and in bad faith that the ACC assumed Florida State was going to file this lawsuit and beat him to the punch in order to try to stop Florida State from challenging the grant of rights? And why would you be worried about that if it was ironclad?
Yeah, so I could talk about the ACC's actions kind of first. They filed their suit the day before the Board of Trustees meeting at 4:55, right at the end of the business day. They, in their complaint against Florida State, which they assert a declaratory judgment action as well, regarding the grant of rights. And in their complaint, they include, somewhere between, I think, like 17 and 20 paragraphs in their, jurisdiction and venue section of the complaint. Meanwhile, in Florida State's suit, it was a total of 4 paragraphs. Typically, what you see in declaratory judgment actions, or actions as a whole, is that the jurisdiction and venue portion of a complaint is typically very small. And, because there's not really an issue as to where the suit is being brought. Now, it's clear that the ACC, when they brought their suit the day before, made venue and jurisdiction a huge issue in their complaint. It was very clear that, they wanted to preempt this suit by FSU in order to try and get home field advantage. That is, very clear by the wording of the complaint. It's very important. And so it's very clear that, I'm not going to speak to whether there's any sort of bad faith, but it does seem that the ACC made some sort of concerted action to try and get the most favorable jurisdiction and venue to them.
While we're on that subject of venue and the effort to have home field advantage, as you put it, well, both sides want that. You and I have talked about this before. Does this then in turn mean that this goes to a federal court?
So that's a little bit of a nuanced issue. Now, we have a suit filed in Florida by FSU and a suit filed in Mecklenburg County, North Carolina, by the ACC concerning the same issue. Now, there are issues with claim preclusion and issue preclusion, which are kind of the civil version of double jeopardy. And so there's going to be either they're going to work together and maybe discuss removing the matter to federal court based on diversity, or the federal court has more discretionary jurisdiction when there's a declaratory judgment action. So there's no guarantee a federal court is going to take up the issue, but the parties could work together, try and remove and consolidate the issue there. Both of these guys have very smart attorneys. I work with Womble and Greenberg, and they're both really good at their job. So I suspect that we're going to find out pretty soon what's going to happen.
The second, I interrupted you rudely and asked you to answer a question while you were answering another question that I had. So let's go back to that other one that I asked you, the second part of that other one. which is how do you begin to tackle what I joked about it, calling it a Faustian bargain. I'm wondering, like, what they looked at as an attorney yourself when you do this, when you look at something that is broad and big as this. How do you go about putting together, I mean, a year's worth of studying this legal document and attacking and finding holes in it?
Yeah, so it is very interesting that this kind of agreement is kept lock and key away
Yeah, like
in
why?
North
Why, Mike?
Carolina. It's very strange. I deal with a lot of confidential agreements where both parties have access to the agreement, and there's no problem with providing access to the agreement to each party. And should you release that information, you're subject to penalties under the confidentiality agreement. There's no reason to potentially keep the agreement in lock and key. It was obviously some part of the agreement between the ACC and ESPN to do that, to hide it away. The purpose for which, it's hard to say at this point, but it's very strange. Now, for them to go up and see this agreement this often, it's costly. It's very expensive to do that. So for them to do that and spend the time to evaluate every single line and every single part of this contract, they were going through it step by step to just kind of isolate, okay, here's where the issues are. You learn, as an attorney, that your job is to issue spot. You receive something and you look through it and you say, okay, where are the issues in this contract or this complaint or whatever it may be? And so they spent time up there looking at it, looking through all the provisions of it, and tried to spot where some of the issues might be. They've got to do their due diligence, and obviously they only have a limited amount of time there, considering it's in lock and key, under lock and key. So it obviously going to take a lot longer, such the year that it took. But it's just kind of a regular process in reviewing and understanding all the provisions and all the possibilities.
To the layman, to think about an agreement to the extent of this one, with hundreds of millions of dollars closing in on $1 billion worth of agreements, to be under lock and key, that nobody can go and look at this. What the hell kind of agreement is that? If you simplify it, like if you and I decide we're going to buy a plot of land together or a driveway or something small, like we're all going to be able to look at the contract. There's money exchanging hands here. What are we doing? That's crazy to me.
And as an attorney and not a layman, it's crazy to me as well. It's very strange. I deal with a lot of the large financial institutions in America, and these companies make millions and billions of dollars, and they don't have these confidential agreements, with parties under lock and key. There are some confidential agreements that, are hidden away from people who aren't party to the agreement. But to withhold parties to this agreement that they are subject to and keep it away from their side is very strange. It's not something I would typically see.
The contractual price of exiting the ACC, i.e., the $429 million in forfeited revenue plus $130 million withdrawal payment, that could be deemed unenforceable. A lot of people have heard that, right? That penalty, you referenced it earlier in this conversation. I want to go back over that because I find that fascinating. In my mind, what I heard you say, and I'm really boiling it down to the simplest of terms here, that seems overly penal. It seems to be absurdist on its face, that cost. Is that, in essence, what Florida State is saying? Hey, this is a crazy amount of money. This is way too punitive.
Yes, that's exactly what they're saying. The relationship to between the fees and what it would cost to exit is just absolutely out of relation completely. The analogy that I give is, if I enter into agreement to purchase, let's say, a Toyota Corolla for $10,000, and you say, all right, you have to pick it up by January 1st, 2024. But if you don't, you owe me $1 billion. That is nowhere near in relationship to the damages
Right.
that's suffered by the person holding the car for another day or however long they have to hold the car for. That would be an example of something they're trying to say is an unenforceable penalty. So the courts kind of go back and forth on this because, when you have experienced parties, educated parties, parties who are involved in high level agreements like this all the time. You know what you're getting yourself into at the time. So in the example, I am not someone that's buying tens of thousands of cars a day, so I don't know what it's going to cost to hold a car, and so it's different in those situations versus these high level actors. And so the courts sometimes will allow penalties that do go beyond what the damage to the parties would be in certain circumstances. In this case, FSU is obviously arguing that regardless, it's just so ridiculous in size that it's unrelated to any damages that anyone would suffer, regardless of whether we knew at the time of the agreement or not.
Okay, this is overly simplistic. It is my final question for now. I was jotting down notes when we first got to know each other and thinking about questions I'd have for you. And I kept coming back to this because I think every Florida State fan wants to just know this. They want a timeline, and they also want to know, is this ever going to go to trial? Or was this meant mainly to bring people to a bargaining table, to create a conversation by which a number is formulated? Now, that's an opinion of yours. It's an opinion of mine. It's a speculative thing. I get it. I'm not asking you to say, hey, I know based on this, this, and this is what's going to happen. We don't know that. But big picture, am I right to think that that's kind of why this happened? Or do you think it will go through trial?
Yeah, and to all of Seminole Nation, the wheels of justice turn very slowly. While we may see kind of where the motion practice is and the answers to the complaint and the removal process with this venue may happen within the next 30 to 60 days, the actual resolution of either suit is going to take a very, very long time. For me, the majority of suits that get brought end in some sort of settlement agreement. Suits allow parties to go to mediation, get at the table, and discuss negotiating an agreement that's fruitful to both parties. And in this case, it's very likely, I believe it's very likely that that's going to be the case. There's going to be some sort of agreement. And the main purpose of that is it is expensive to bring a lawsuit. It's expensive to go through discovery. It's expensive to bring motions. It is expensive. And so that expense alone will most likely bring people to the negotiating table. Now, we will see when how this plays out, how discovery plays out, where this is likely to go. But I do think that this is something where both parties are going to talk and sit at a table and say, okay, how can we work this out? Whether it be letting FSU leave the ACC or by working to try and get some sort of new agreements or unequal revenue distribution, something that's going to be fruitful that will allow the parties to save face and drop both suits.